Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
Good morning, everybody. Thank you for sticking around. I'm your last speaker today, and I'm going to be talking to you about fiduciary relationships in the employment context. We're going to speak a little bit about how fraud can give rise to a fiduciary relationship, and then we will discuss what obligations fiduciary employees have to their employers when they depart. There are three factors that tell us whether or not an employee has a fiduciary relationship with their employer. They are the employee's ability to exercise discretionary power, the authority delegated to the employee to affect the employer's economic and legal interests, and the degree of trust placed in the employee by the employer. Finally, what is the extent to which the employment relationship renders the employer vulnerable to the employee? We will now talk about when a fiduciary obligation is imposed. What does that mean? Well, the Supreme Court of Canada indicated that a fiduciary must act with loyalty, good faith, and to avoid any conflict of duty and interest. This is a significant and exacting duty. It is logical that senior management and key employees attract this duty. And why is that? Well, that's because they're exposed to certain important employer information. Access to clients. That's a big one. Do they interact with the customers, suppliers on a regular basis? Do they have access to confidential information? Trade secrets? Profit and loss data? Would they be able to significantly harm their employer if they were to leave and take this information with them? Not only does it apply to senior employees, in certain contexts it can apply to more junior employees. One of these reasons is fraud. In particular, courts have imposed fiduciary obligations on employees who have committed fraud against their employer. The courts have been increasingly cognizant of an employer's vulnerability to lower-level employees who are in a position to commit fraud against their employer. They have not hesitated to impose fiduciary duties on those employees, especially in situations where these employees handle the employer's funds and have shown themselves to be faithless in their duties. There was a case of Navrav Investments in Vadian. In this case, an employer, he was a night manager of the store, and he stole over the course of about 6 months some $78,000 from the cash register, a significant amount. The employer had a real concern when they sued him for this loss that he would simply claim bankruptcy, and therefore the liability towards the company would be wiped out by his declaration of bankruptcy. However, and this is because there was a general rule, maybe we've caught up to the slides, there's a general rule that a discharged bankrupt is not liable for debts incurred prior to his assignment. But there is an exception now carved out by the courts where this debtor liability was incurred as a consequence of a breach of fiduciary duty, and therefore they would still be liable for these funds. Simply a declaration of bankruptcy would not allow them to escape repayment. Another recent case of the Court of Appeal for Ontario has indicated the willingness of courts to impose fiduciary obligation on lower-level employees is not restricted to situations where the rules of bankruptcy might work against the employer. There's other circumstances. And in this case of Enbridge Gas, somewhat interesting, there was a contractor who had a scheme to defraud his employer. Essentially, instead of actually doing projects, he would be hiring his friends. They would be submitting invoices, and the company would pay them for work that was never done. By the time the scheme was discovered, the company was defrauded to the tune of $6.5 million. In imposing fiduciary obligations, the court concluded that this employee's very ability to perpetrate this fraud was enough to give rise to a fiduciary duty. On a side note, the employer also gained another important advantage in this case. They were granted the ability to sue the fiduciary employee's partners in the scheme for the tort of knowingly assisting in a breach of fiduciary duty. These cases show that courts are mindful of an employer's vulnerability to employees who, while they may not be senior management employees, exercise their discretion over a certain sphere of the employer's enterprise, and they possess the ability to cause considerable harm to their employer's interests. What obligations do employees owe their former employer? And here we're talking about those more senior employees who do owe a fiduciary duty. These can be vice presidents, presidents, CFOs. Really, it can be anyone who meets the threshold of what a fiduciary employee is. And as it says up there, these obligations do not have to be written within an employment agreement. They're implied through the common law. And fiduciary duties are usually, however, less restrictive than, say, a non-competition agreement, which can be in writing. Some of the duties that these employees would owe their employer are the following. The first is fidelity. All employees owe their employer the basic duties of loyalty and good faith. These duties are referenced in specific obligations that can be spelled out in an employment contract. Some of it can be as easy as, don't steal clients, don't steal funds. There's basic principles inherent to any employment relationship. And some of these duties will survive even the end of the employment. Next is the duty of fair competition. While non-fiduciary employees or low-level employees are often free to compete with their former employer as long as they're not violating any non-competition or non-solicitation agreement, fiduciary employees owe an obligation to not compete unfairly against their former employers. This obligation includes not directly soliciting their former employer's customers, clients, or employees. Moreover, it is considered unfair competition for a fiduciary to take advantage of a former employer's business opportunity. And that goes for cases where even the former employer is not in a position to take advantage of that opportunity. The only way that this fiduciary employee could take advantage of such an opportunity would be if it was readily available to the public at large. They couldn't have learned of it only because of their past relationship with their former employer. A fiduciary's duty not to compete unfairly continues for a reasonable period following the termination of employment. And the court will often weigh several factors in setting a reasonable period of time. However, this period does not usually exceed 1 year. Next is the duty of confidentiality. All employees have a duty to refrain from disclosing or improperly using confidential information that belongs to a former employer. This duty is not limited to written or electronic documents. In fact, if they've learned of research, if they've learned of proprietary information, and it's all in their memory, they're still restricted from using that information to their own gain. An employee must maintain this confidentiality and cannot use the information to compete with the former employer in any way. However, the general knowledge and expertise that they have gained from their on-the-job training working for the employer is something, of course, they can use to their advantage going forward. Finally, there is a duty to give reasonable notice for fiduciary employees. While most employees can simply come into HR and hand you a letter and say, here's my 2 weeks notice. It's different for fiduciary employees. The length of notice depends on several factors, including the length of service, the character of employment, the employee's age, and the availability of similar employment for this employee. In fact, they're the very same factors that employers must consider when dismissing an employee. So the court will consider all of those factors in determining just how long someone has to give notice to their employer. Some things that fiduciary can be restricted of is, again, taking the customer list, soliciting clients. They can't divulge trade secrets. They can't take advantage of maturing business opportunities. And, of course, they can't make unfair use of information acquired during employment. And this comes up, especially the one about business opportunities, comes up quite often, where someone learns of a prospect, a land deal, a stock prospectus. It could be anything. And because of that, they say to themselves, hey, I can make a few bucks for myself. And they leave and turn around and try and take advantage and steal it right from under their former employer's nose. And the courts have said, absolutely not. You cannot do that. And this is the leading case on that very topic. It's a gas tops case, and it's a recent ruling of the Ontario Court of Appeal where they upheld the trial judge's earlier ruling. In this case, the defendants were senior employees of the plaintiff. There was about 10 of them. They all walked in the same day to HR and gave their 2 weeks' notice. Started a new company which did exactly the same thing as their former employer. According to the evidence before the courts, they used the opportunity that gas tops had given them and stole customers, stole profits, stole business, made some $13 million that the court said rightfully belonged to their former employer. Further, the court said the defendants had competed unfairly by misappropriating and using confidential information comprising of confidential business plans, information about particular customer needs, and confidential technical information. The court also said that the 2 weeks notice that was given was simply not appropriate. And this case confirms the importance courts place on the obligations of senior employees to their employer and their responsibility not to use such confidential information. Essentially, they were ordered to pay 10 years' worth of profits back to their former employer for their violation of these duties. The takeaway from that case is simple. Organizations should review and ensure that key employees are covered by employment agreements containing well-drafted restrictive covenants and prohibitions against the use of confidential information. In the gas tops case, there was nothing explicit down on paper which prevented the employees from doing what they did. The employees may have felt that they were free to do that. They may not have been aware of what their fiduciary duties were and simply took advantage of the situation. Had something been in writing, it would have been clear that they were violating, and the trial would not have taken some 295 days over a period of 7 years. So what to do? Well, we would suggest that prudent employers insist that their employees sign agreements to deal with these issues. Wherever possible, the agreement should be signed before the employee starts work so that there's no unilateral change of an employment contract which could give rise to some sort of constructive dismissal, as was discussed earlier. The employment contracts of senior or key employees should set forth clearly their fiduciary obligations. All employees should sign standalone confidentiality and trade secret agreements so we can define what is confidential, what is proprietary information. It's clear, so if they take it, they're liable. And lastly, all employment contracts should specify the amount of resignation notice. This is for your senior level employees. If you have people who are crucial to your business, you don't want them walking in and resigning with just 2 weeks. It might take you 6 months to find somebody who can fill that role. And if that's the case, you should put it down in writing. Thank you for listening today. I know it's been a long morning, and we appreciate you sticking around. Thank you.